Mr. Chair, I know the appellant for the Victoria Street file wanted to participate. So we'll just give him a second to arrive at the meeting before we commence, if that's all right with you. Oh, and there he is. So you're free to start whenever you want, Mr. Chair.
I can't hear Councillor Hutchinson. He's on mute.
Sorry about that. I'm used to the chair being unmuted before the fact. Okay. All right. So I'm calling the meeting to order. And the first item, everyone hear me now? Just nod. Okay. Is the approval of the agenda with the addendum. So moved by Mr. Storms and seconded by Councillor McLaren. Okay, any additions or subtractions? Seeing none. All those in favor? Okay, that passes. And confirmation of the minutes for July 20th, our last meeting, 2020. Do I have a mover for those minutes? Ms. Wallace, seconded by Mr. Knox. Any comments? Seeing none, all those in favor? And we'll go from there. That passes. Disclosure of pecuniary interests. Any pecuniary interests by anyone? Seeing none. The delegations, there are non-briefings, there are none. So we're on item 7 now, business, new appeals.
Mr. Chair,
Yes.
could we quickly go over some brief introductions just so everyone is aware of who is here and what their role is?
Oh yeah, sure.
Sure.
That right now, actually. Okay.
All right.
We can start with, you want me to start with the committee?
Sure. Yeah, you can just more or less mention who's here from staff and the committee members' names, and I think that suffices if you are comfortable with that, or I can do that as well.
Okay, sure. Okay, so on the committee, we have Ms. Wallace, Mr. Knox, myself, Mr. Storms, and Councillor McLaren. From staff, we have Dan Hazel, I'm not sure who Mr. Francois is. Is he a staff member?
No, he's involved with the Montreal Street file. He's the appellant.
Okay, fair enough. Okay.
We have Kyle Compo, Jonathan Baldwin, and Andrew Gemmo from staff.
Okay. All right. So having done that, now we'll do item number 7, business, new appeals. The first one is subset I, or 542 Victoria Street. The following item is much the same. Okay, it's right next door. So Mr. Mock is here, and we've received some notes on that in the addendum. So the staff wish to introduce this item, please? Mr. Hazel, perhaps, or?
Hello, everybody. Committee. I hope you're all staying safe during this pandemic. Through you, your chair. Essentially, we have a property standards officer, Officer Cummings, who's handling these 2 cases. She would be here at the meeting to provide the update and what's gone down, but she's off today, so I'm going to try to provide those details in her place. Essentially, 542 and 544 Victoria are owned by one property owner. 542 has some exterior items that are still left to be dealt with on the order. Most notably, some outside doors, the roof, and there was some debris and refuse concerns on the exterior of the property. And then 544 is an order that was issued to deal with the inside of the property, the interior, based upon an inspection that happened in August, on August 10th. There's still some items on these orders that have not been complied with. And we're still in the process of achieving final inspections to see if they perhaps have been resolved already by the property owner. There's been some discussions with the property owner about issues and concerns to why the items have not been achieved yet. And I think he'll speak to those shortly. But more or less, there are some landlord-tenant issues going down with the property that the city would not be involved with or have any governance on that process. One of the orders, the one for 542, which is the exterior items, is due until October 27th, so it has not passed timeframes for compliance yet. And the one for the interior property was due for October 14th, so last week. So I'm trying to keep it quite simple. We used a yards order as well through the process to deal with some of the matters outside, some of the refuse, construction materials, and things of that nature. And we did achieve some voluntary compliance through the property owner to get some of those items rectified. So the remaining things that need to be addressed would be the exterior items of the property, which is really windows and doors must be free of all defects, including peeling paint. Exterior walls must be free from cracks, holes, and additional defects. And the roof has to be repaired in the sense that it has no loose shingles and has to be waterproof. So those are the items remaining at 542. And at 544 on the interior, windows must be free from damage, decay, and free from any peeling paint that was observed by the officer. There was also some walls, floors in the entire building that had some cracks and holes and loose coverings that needed to be rectified. In addition, the exterior of the building needs to be free from any peeling paint or any defects. All the windows have to have proper screens and maintained in good repair. Hardware on unit number 3 needs to be repaired and replaced in working condition. And that's a reference to the door and that location. And a shower has to have proper hardware and maintained in working condition. I believe there are some photographs that we did provide through the clerk if they'd like to be viewed or whatnot. Most notably for the interior inspection, there were photos dated August 10th, 2020. In addition to that, there's 3 photo sets from the exterior property. The first set was taken on May 26th. The second set's from June 19th. And the third set is from August 26th. Final inspections are still due to be completed. And the property owner appealed this to the appeals committee to request, I believe, extension of time. And that's why we're here today.
Okay, any questions from we're just looking at the pictures for now. Maybe since we can't hand them around, we'll let them finish through.
Those photos we're reviewing right now are from the June 19th inspection by officer, showing some of the exterior things that were discovered.
Mr. Chair, while Elizabeth shows the remainder of the pictures, I would just like to mention to the members of the public and staff that if they wish to speak during the meeting, to please use the raise hand tool within Zoom to let us know that you would like to address the committee. To do so, please click on the participants icon in the lower menu within Zoom. Once that loads the screen or the menu on the right hand side of your screen, there should be a little button in the bottom of the screen that says raise hand. So please utilize that tool as necessary. Thanks.
Thank you, Mr. Clerk. Okay. So I'm sure if the committee wants to see any one of those again, we can figure that out somehow. Oh, we're not done.
There are several pictures. Would you like us to stop and then we can refer to these if necessary?
Yeah, I think we're down to the last 4. Okay, is that okay? So any questions to staff from the committee members? Ms. Willis.
So I wanted to ask Mr. Hazel if the officer observed any life safety issues during their inspection.
Through you, your chair, there was no life safety violations within the interior portions of the property. They seem to be of maintenance issues or keeping of maintenance concerns. There were some noted life potential hazards under a yards bylaw that were issued in a subsequent order that's not part of the property standards process that have been corrected. But in terms of the exterior and the interior, there's currently, to my knowledge, no life safety issues.
Any other questions? I see you, Mr. Knox. Ms. Willis, were you finished? Okay, Mr. Knox.
The mention of the hardware for the door, is that a security issue? That the door won't lock or function properly?
From the photograph that I have displaying the hardware to the door, it looks like the door is functional and the lock does function. It just looks like the hardware might be out of joint and the surrounding wood around the lock might have a gap in place. So within the standard of the bylaw, that stuff has to be aligned and covered. And to my knowledge, it does lock and operate.
Thank you.
Okay. A question, are the buildings, look, we're dealing with 542 Victoria here. I think I should make that clear since that's the item that's up, and then we'll deal with 544 in a minute when we're done there. It'll be cleaner that way. Are the buildings still, or is 542 still occupied? The addendum seems to suggest it is, I'm not sure.
To our knowledge, it is still currently occupied with occupants and some tenants.
Mm-hmm.
To my knowledge, there is a landlord-tenant proceedings that the property owner could speak to and where the progress and status of that is.
Sure.
But to our knowledge, it is still occupied.
Okay. So with the Ms. Willis.
Mr. Hazel, just if you could clarify, so for 542, items 1 and 2 that deal with the vehicle and rubbish and debris, those 2 have been satisfied?
At this current time, we are satisfied with number 1 and 2, meaning that number 1, the vehicle, I believe, has been licensed with a VAL tag and is now roadworthy again. And substantial amounts of refuse and debris has been removed from the property and organized into a manner that's acceptable. I understand that there are some repairs and construction going down in the future at this location, and the property owner intends to use these materials, and they're not discarded, and they have been organized.
Okay.
The rest of the items on this order really pertain to the exterior doors and the roof, and getting those repairs completed.
Okay. Thank you.
Thank you, Mr. Hazel. Okay, with the committee's permission, I will move on to the response from the landlord to the presentation. I see nodding heads. Okay, Mr. Mock, I believe you're present. Do you have anything you wish to say?
Yes, I have drafted a synopsis of what has been going on for the past few months. Basically, in a nutshell, I have rented the place to one tenant for both places, and he has been subletting it out to occupants, which I am aware of, but those occupants are not my tenants. And in around July, there was some kind of issues between my tenant and the occupants, where the whole group are not paying rent. And as a result, they are creating quite a lot of mess in the yards. They are creating lots of damages to the house. We're trying to intervene, but obviously it's not working. Police has been called. Police said nothing can be done. And there was a few instances where we tried to get in with the agents, and someone just rushed into the door and slammed it closed. It's pretty dangerous. And there was time where we were there with the tenant at 544 Victoria with the police, and one of the occupants attacked the tenant and broke the phone, and the police was able to intervene. All this can be found in the police reports if I do request for it, because I'm sure the police has all the summary. And obviously, because of this occupants, which are not my tenants, they have created a lot of mess, noise, a lot of complaints, which City of Kingston bylaw officer should know about it. Police do know about it. So by around late July to early August, my tenant has been fully kicked out of the house, has no access to either side of the house. In other words, those occupants are illegally residing on the premises. Around the same time, after we learned all this, we engaged a lawyer in mid-August to evict those occupants. And speaking to the lawyer, he said, as long as the main tenant sign an agreement to be released, which is the N9, he can evict those occupants, because technically, as a landlord, I have no relationship, no contract with those occupants at all. And besides, we don't even know who they are. We don't know the name, the phone number. We have no information about them, whoever they are. From my understanding, some of the occupants re-sublet out, and there's other people in there right now. The reason why I can't let my people in to fix the things in the interior of the house, or even just touching the house, is because it's pretty antagonistic in there. I don't want my staff to get hurt. Like I said before, the tenant was attacked once. The store was at 544 Victoria, and the door was slammed once when we tried to go in with an agent, and it's all in the video. So I do think that without eviction is I don't think it's fair for me to just send someone in and probably get hurt. I've explained all this to the City of Kingston, the bylaw standard officer and the supervisor, but they say that is none of their business. Their business is to make sure everything's up to code. I totally understand it should be up to code. First of all, they walked in without letting the owner know that they're doing inspection. Had I explained those things, that those people who actually made the call are the occupants, which are not even tenants. In other words, they are just, according to my lawyer, they are just illegal squatters from the actual tenant. So as a result of all this, we have decided to evict them first before we can send someone in. And from the timeline that the lawyer gave us, mid-September is when the tribunal actually opened. There's a huge backlog, and he do expect that by around late November to early December, the order can be obtained, and a sheriff can be hired to evict any occupants that are in there at that time, and we're going to change the lock. Once they're fully evicted, we do have plan to fix anything that is required. Bear in mind that City of Kingston personnel just walk in because the occupants invited them in without the knowledge of the owner, which I think should be appropriate to at least let the owner know, and they should know what's the situation like. It's like a whole bunch of thieves went into a house and called the police on the owner. So I find it very unfair to the owner, because my whole family has been investing in Kingston for over 30 years. And this is the first time we have to go through this stages, because we don't find it comfortable to let anyone in to do any repair and maintenance. And besides, those repair and maintenance are not something I think is not that crucial in terms of people living there. We're talking about just some peeling paint. There is no leaking. There's no like, things are functional. I know it's a little bit rundown. The reason why is we can access the house to do anything. So right now, my request is, I am pretty sure that we can get the order from the tribunals, filed with the court enforcement officer, hopefully sometime in late November, early December, as per the lawyer. And once all those are done, I can finally get people in to fix things. There should not be anyone living in there once they're evicted. And then I hope to get extension to mid to late January, just because if I do have them evicted by early December, comes the Christmas time, I do need time to get it fixed. Obviously, as a landlord, I can leave it that way, or else no one's going to rent it. So it is a lose-lose situation for me for not fixing it, because I'm not getting any rent right now, because my main tenant has been forced out of the house by occupants. I don't know where these people are coming from, but they seem to be very aggressive.
Okay, Mr. Mack, I'm going to, I think we're repeating some things here now, which is normal conversation, but we need to come to a decision at some point here. So I know I have some questions. Do people on the committee members have questions? Ms. Wallace.
Mr. Mock, have you, at this point, it's sort of a two-parter, have you filed an application at the tribunal? And second, have you received a notice of a date for a hearing?
Oh, according to the lawyer, he has filed it back in around late August. The thing that it cannot be processed because the tribunal was not open until mid-September. And yes, the lawyer already confirmed that the tribunal has all those things in their hand. They just have not, how do I put it? They have not processed it yet. Okay. Just an acknowledgement. But at the end of the day, he doesn't know the exact dates that he can get the order. There is no need for hearing, according to him, because those are just occupants. Those are not even our tenants. Mm-hmm. The main tenant who we signed with has already submitted an N9 for lease termination. So anyone is in there is not supposed to be in there.
Okay. But you do not have a date for a hearing yet?
According to him, there should not be any hearing. They should be getting like a letter from the tribunal, because these are evicting occupants that has no relation with the owner.
Okay. Thank you.
Okay. Any other questions from the committee? I mean, I think staff are correct that the LTB issues are not really the city's issues. I would say that it seemed to me that you allowed, Mr. Mack, that you allowed the sublet and that you were not the direct landlord as far as the sublet's concerned. That seemed to me what you said. And the importance here is, you know, what can we expect you to do and in what time period?
Now, in terms of the orders, I have the vehicles removed. I have paid people to clean up the yards. It's all been organized. It's also been verified by the city of Kingston. So obviously, yes, I am planning to do work on it. It's just a matter of accessing it. I don't think it's safe. And I gave you the 2 examples already why it's not safe. So right now, I don't know what to do. Like, I want to get it done as soon as possible. Once they're evicted, I want people to go in to fix things. But now it's just a matter of getting eviction. And according to lawyer, it is a matter of time. He's thinking around late November to early December. They should get a order from the tribunal and file with the court enforcement officer. And the sheriff would give like a week notice on the door. Whoever is still left there, they will be going out and enforce people to leave.
Right. Any, okay. So, now, it seems to me that doors and roofs are still involved as far as what the main things that were still involved is per what staff said. That's one point to be made, which sounds fairly serious. The has the committee got any comment at this point? Mr. Storms.
Mr. Chairman, just it's more of a summary maybe, but, and I'm not going to speak for Mr. Mack's lawyer, but being a lawyer who's trying to deal with tribunals and stuff that have been closed because of COVID, I think what's happening generally with the landlord tenant, and I don't know this case, but I think what Mr. Mack's saying, or what I'm getting from what he's saying is those applications that are in his case being done are being done in writing. They're not being done in hearing. So he's not going to get a specific date because they file all the, and I've been doing this too. You've been filing all the information on somebody who in his case is a squatter. So the only thing I'm concerned with is the stuff that he can do that doesn't pose a danger to anybody doing, he should do. And anything that does pose a danger, I appreciate his point. If he's got aggressive squatters there and he needs the sheriff to do it, he needs the order for the sheriff to go in to do it. So I can appreciate that he needs an extension for the things internally that can't be done in case somebody's going to get hurt. I have an appreciation for that, but I just want to make sure that everything that can be done is done. So that's just a general comment.
Okay, that's good, and that fits in with Ms. Willis often raises the issues of safety, and we do make that of the people in a particular abode. So I think that's important. I guess to me, I'm going to ask staff, I think, what they think could be done before Christmas, since that was the date that Mr. Mock raised. Mr. Hazel, would it be reasonable to expect the roof to get done? I don't know if it is or it isn't. Those are the kind of questions I think before the committee at the moment.
Yes, good questions. And through you, your chair, I think what we're looking for right now would be a maintenance plan to really address all the issues on the order that's for the interior based items for 544, and a maintenance plan for the exterior items such as the roof, which might include some quotes for services to get those repairs created and some potential timelines. We're empathetic to the situation going on at the property with the LTB. We recognize the challenges that might provide to get maintenance occurred. But we're just hoping to get compliance of our orders in a reasonable time frame. And as of right now, the expectation on the orders is by October 27th for the one and October 14th for the other. We're not in a position to grant additional extensions beyond the order compliance times, and that's the role and purpose of the committee. But we're definitely happy to receive a maintenance plan in an appropriate time frame that the committee feels necessary. And we would work in conjunction with the property owner from that point forward to try to get compliance of the orders and hopefully come back to the committee at another date and time to provide progress and or no progress updates.
Okay, that's good. Thank you. So I'm just going to put out this.
Mr. Chair,
Sorry, Mr. Clerk.
Mr. Compo had something to add, if he may.
Certainly.
Thank you. And through you, Mr. Chair, I also just wanted to make the committee aware that I'm cautious to set precedences by the decisions that we're going forward with. For previous cases, again, we've been reluctant to get into civil disputes. In regards to an occupant, under the property standards bylaw, that definition of an occupant means any persons or persons over the age of 18 years who appear to be in possession of the property. So that's what our definition of an occupant is right now. And again, in terms of Mr. Mack's just response, our officer has been working diligently with the property manager, and that in these circumstances for inspections is that the property owner does not have to be made aware of the inspection. We have certainly a large amount of cases where the tenant does not feel comfortable speaking with the property owner, and that they have the option to contact the city directly without going through the property owner, and that we do our due diligence afterwards. And that's where Mr. Mack would receive his formal notification of the inspection, and we encourage him to reach out, which he has done to the inspector.
Thank you. I think I recognize that as well, besides the fact that there's an agent, a letting agent between the owner, Mr. Mack, and these subletters who, I guess the LTB has to decide, what their status is. So my inclination, and I stand to be corrected by the rest of the committee, is that we extend this order with the provision for a maintenance plan by the November meeting. If that works through the clerk in terms of timing. I think that works with what staff are trying to do. And it also means that possibly we'll have a legal, you know what? I think we would like to see some proof that this is, no offense to Mr. Mack, but we're in the dark to some extent here. So we would like to see some proof of the legal proceedings that, a request to the LTB has been made, for example. And also the maintenance plan, which I think a month is sufficient time to come up with the basics of that. I'm looking right at Mr. Hazel at the moment. So, and then we'll give an extension in which the committee can decide on. Is Ms. Wallace? Or yes, and then Mr. Storm.
So ordinarily, sitting in a meeting in mid-October when there's a bunch of exterior maintenance items before us, I would be wanting to see those items completed just because of the weather. Because once the weather turns, nobody's painting anything, and we're not putting on a new roof in January. It's highly unlikely anyway. So ordinarily, I would be saying I think that we need to see movement. However, in this case, I have some concerns about the safety of a crew that might be on scene for multiple days. I don't want to hear that a crew of roofers was attacked or there was an altercation or, their ladder stolen or whatever, damages, etc. So I find myself a little bit torn because I know a lot of these items are just going to probably be extended again. But with the provision of a maintenance plan, I'm a little more amenable to the extension of exterior items. in mid-October with the sort of mitigating factor of the safety concern at the property.
Okay, thank you, Ms. Wills. How do you feel about some evidence of movement on the legal front?
I think that would be nice to see at the next meeting. That is a little bit outside the purview of the committee, I think, but it would be nice to know that where the intention lies, right? That it's sort of a good faith, I guess, showing along with maintenance plan.
Okay, to be clear, I'm using the evidence of legal process as a marker
Yeah.
for what we can expect to be done in terms of maintenance, right?
Yeah.
I agree with you that we don't have any say about the legal part of it, but I think we're within our purview to say we want to see movement on the legal front so that we can adjudge properly how much time should be allowed for on the maintenance front.
Yes, agree.
That's the way I'm thinking.
Yeah.
I see Mr. Storms nodding and he is,
Yeah, I agree with you, Chair. And I was just going to say, if Mr. Mack is correct in his assumptions with respect to his lawyer, the application would have been filed in order for those conversations to have. So just, I agree, we don't have any say on the legal front, but it's easy enough to get the application to see where they're at in the process. And that's Mr. Mack's lawyer should already have that. So, and it's a matter of public record, so it's not a solicitor client issue. So I agree with everything you're saying.
good. Thank you. Yes, and all we need is a copy, right? To indicate that the process is in place. Mr. Mack, I'll just say that people say lots of things in front of this committee. So we're just trying to, it's not about you, okay? Personally, it's about our need to do our jobs properly. So is someone willing to make a motion to that effect, or may perhaps have more? One more question. And then Mr. Storms, I'll come back to you. Mr. Hazel, does that sound reasonable to you? In terms of a maintenance plan, you mentioned that. And
that sounds reasonable. My only comments would be that the maintenance plan should be quantified into two categories. One, how we're going to handle the exterior components on the order that references 542.
Yep.
Component of the maintenance plan should be referencing the 544 order, which is the interior items on that order, and what's the plan for that, with associated timelines and potential quotes that kind of show due diligence has been achieved, which
Right.
then would really allow us to really do a comprehensive reply at the next meeting.
Okay, so I think we'll take that as understood to be part of it. And the clerk, did you manage to get enough of that to make it go?
I believe you are extending.
Mhm.
I believe you are extending 542 Victoria Street to the November 16th meeting in order for the appellant to provide what term did you use there? The maintenance plan, which includes a quote and timeline, as well as evidence of the tribunal process being underway.
Yes, and you can check with Mr. Hazel what he wants to see in that reference to the maintenance plan about exterior and internal items. Is that okay?
Through your chair, that is okay. And I just think it should be one for 542 as described by the clerk, in addition to the exact same one for 544. So it'd essentially be two maintenance plans that cover off those orders. And I'd be happy with that.
I think we would be too. Thank you. Mr. Storms, is there a further comment?
Oh, no, Chair, I was just going to move it for you. That's all.
Okay, we'll take that. And is there a seconder? Councillor McLaren. Okay, so any further discussion now that the motion is on the floor, on the table? Seeing none, all those, and we're voting on 542 right at the moment, okay? All those in favor? And that passes unanimously. Now, thank you. Now we move on to item I believe it's II 544 Victoria Street. I think personally that we just make the same motion and substitute the address, right? 544. Mr. Clerk?
That's likely appropriate, Mr. Chair. We should afford Mr. Mack an opportunity to provide comment, but
I
short of that, I think.
totally agree. Yeah. Mr. Mack, do you have any further comment, please?
Going back to a gentleman by the name of Kyle who talked about how inspection can be done without knowledge of the landlord, I totally agree with that. But it's only applicable when tenants are actually living there. But right now we're talking about someone that are illegal squatters that are in there, do all this complaining because they're not paying rent to the tenant. So I don't know what is the actual procedure, what is the actual guideline for it, but I don't know whether that can be improved or not. It's like I said, people can rob a house or go into a house as thief, and then they call the police and make all this request, and the city of Kingston would believe them and do all this work. At the end of the day, none of this repair and maintenance it's crucial, don't get me wrong, but they're not endangering anyone living in there. And besides, I have no tenant living in there right now because it's been kicked out, forced out. I don't know why I have the responsibility to occupants. According to the lawyer, I have none, period, because the tenant has given me the N9 and he was forced out, and that's it. That's why there is really no hearing. Whoever is in there are just illegal squatters. That's why it can be removed, according to the lawyer.
Sure.
So coming back to 544 Victoria, I don't really have much more to add aside from once the eviction is done, which I hope the sooner the better, I am getting people to get things fixed, and I will be contacting Dan or whoever who's on this file to walk through with my staff, just exterior, not interior, because I don't feel safe to go in. Well, not me personally, my staff, because of the two occurrence already with police presence, but more on the exterior, what exactly pinpointed and show it to us what exactly needs to be done, because what was written on the order is somewhat detailed, but it'd be great if they can just point it out. So I can talk to the roofer about it, exactly what was done, because from our understanding, the roof was about 5 years old. It's been replaced before, but there was a fire on Princess on that big development, and I don't even know if that was the cause of the roof decay, but the roof is less than 5 years old.
Well, that's certainly unfortunate, and I understand what you're saying. I think that Mr. Hazel will certainly take that into account, or staff in general, and they'll usually they're very willing to go out and have a look and be more detailed about what is necessary to come up to the code or up to the bylaw. So I would say on that when someone phones, like I've dealt with this myself, property management, when they phone staff gave the reason why they go out, and that is unavoidable. The city at that point does not know whether someone's there legally or not. They take that for granted because 99% of the time, as you allowed in your previous comments, and indeed the tenant is legally there. In this case, we have a different state of affairs. So, in that complicated legal situation, which has to be proved at the LTB, and we are not the LTB. So, I mean, I'm taking your word for it that what's happening is happening at the LTB, and you're correct in your description. But the city would not know that in the beginning, or necessarily have any legal say about that. That's our situation. So do we have the motion, Mr. Clerk? Have we had the motion for 544 Victoria on the table yet? On the floor?
No, we do not have a motion on the floor yet,
Okay.
Mr.
So could I have a motion from Mr. Storms and a seconder? For Council McLaren? Okay, and any other discussion? Seeing none, all those in favor? Okay, Mr. Knox, I cannot see you, so your video is off apparently. So just thought maybe he popped back up there. Okay, so, all right, so we dealt with that. And now we have 1081 Montreal Street. And I will ask, there's the officer right there, Mr. Baldwin. So, and perhaps you can update us on this.
Okay, can everyone hear me?
Yes, I think.
Okay, so I believe we were last in the appeals committee for this in July, I believe. I think the result of that was we were just pushing for today, just for a check-in to see how the property owner's doing. I think it was in regards to the heritage portion of the property. I was there on previous Friday. Everything seems to be in order. Same as the last time I was there in July. There's just some refuse and debris on the property. It's mostly blown off the street, off Montreal property. So other than that, I think what we're waiting for is to see how their heritage consultant's been doing with the property. So.
Okay. No, I'll just go to the committee for start. Where my impression is, Mr. Baldwin, that we're looking at an extension here, possibly, and because the heritage aspect has not been taken care of, for one thing. And one question I have, which might speed things up, are there elements of the original order that could be that have been completed? You say there's some refuse, and that may not be even the fault of the landowner.
No, the majority of the order has been completed.
Mhm.
And we're just kind of waiting to clear items 6 and 7, I believe. But I think that's what we were waiting on, the heritage aspect to check those off. I'm not sure if you guys have the order.
Yes,
in front of
yes,
you there.
because they're interrelated, yes. Okay, the committee, does the committee have any questions or remarks? Questions at this point? Not seeing any. I want to ask the clerk, is it possible to extend this with just items 6 and 7?
I will defer that question, Mr. Chair, to Mr. Hazel to see if he would like to keep the order intact or if he would like to close elements
Sure.
of the file. I will also mention that Mr. Francos, who is the property owner, is here, as well as Mr. Keene.
Okay, I'm going to go to them right after Mr. Hazel.
After I think about this one, I would love to get components of the order closed. I'm just hesitant to do so without seeing heritage progress or heritage applications getting applied for the property.
Mhm.
I would just not want to be the municipality be in a position where the heritage attributes don't go through. We've closed an order, and then we're in a position where we might have to reissue a new order. That would put us back at the beginning of the process. So I'd be more in a position to recommend we do not eliminate the order or modify it, and still go forward and come back with another update another month or 2 months time.
Okay. So does Mr. Francos or Mr. Keen have any comment?
Go ahead, Mr. Franco.
James. Can I go ahead?
Yeah.
Okay, great. I have, so Jonathan, thanks for the comments. I would like to say that, we have a local contractor working to keep the property clear of all debris and rubbish. And so while there is from time to time some debris and rubbish that builds up there, I will say that our contractor, Mr. Ron Weaver, has been doing a good job of keeping the place clean. Unfortunately, I will also mention that locals seem to use the property as a somewhat of a dumping ground because we haven't started our activities yet. So we've got somebody coming by definitely once and sometimes several times a week to clear debris. And we're quite committed to maintaining the property in good order as the city would like. I will mention that we have had a structural assessment done by John G. Cook and Associates, consulting engineers that are familiar with heritage buildings. And they have observed that while the condition of the masonry is fair to poor, the basic structure of the wall is in good condition. So I believe with this confirmation that the building is in good structural condition, that in fact, we have met all of the items on the order to remedy. So I'll just bring that point. There was a recommendation also on the July 20th City Appeals meeting that I think it was by Andrea Gummo, that the city staff or the planning department take the file from here. So we're happy either way. I can tell you that we are committed to our, as an owner developer, we are committed to our development of seniors apartments on this property. That will be moving ahead. The process has been a little bit slower from a financial planning point of view or funding point of view due to the COVID pressures. So it's caused us a little bit of a setback, but that is changing rapidly now. So we expect to be moving ahead through the course of, actively through the course of the winter time and completing our applications to the city and our final designs, etc. So we are cooperative. We're looking forward to working with the city on this file and completing the final aspects of what we will do with the farmhouse in the context of the environment.
Okay, thank you.
Mike Keen?
Yeah. Mr. Keen, did you have something you wish to add?
Maybe just briefly and more directly to your question about heritage and the site plan application. So as Mr. Francos mentioned, we have our heritage reports complete, but it's all as part of our development application. It's the heritage application and the site plan are going to go hand in hand, and our architect still has to make a decision on whether to restore the existing building or whether to retain the building as a ruin. So the heritage decisions haven't been made yet, and that's why probably from your eyes you're not seeing a lot of difference from July to today. But we are actively working, but we can't advance the heritage application until we make a decision on restoration or restoration as a ruin. Thank you.
Question here is, what is the timeline for submission, I guess, of the application with the heritage plan?
Through you, Mr. Chair, I think it's going to be the new year. I don't know if I could give you a precise date, but just just with the way things have slowed down, I think it will be sometime in the winter, January to March. But I don't know if I could be more precise than that at this moment.
Sure. So I'm just going to go back to Mr. Hazel. I mean, I think what we're looking at here is an extension. So I'm looking for what you could think would be a reasonable time date, like February or March. We made it March. You could activate it sooner than that through the clerk. So just tell us what you think would be a reasonable extension.
I think the reasonable extension, and I'm happy to provide the estimated time that was provided by the property owners in the new year, January, February, March. I'm not obliged to any one of those months because the process is quite lengthy. To achieve the studies that are required to go forward with heritage work is quite costly. We want to work with the developers and the owners to make sure they're in compliance. From our property standards perspective, the biggest concern we have is any construction or alteration going forward without a heritage permit or approval from planning departments. Once we see applications go in, and once I hear from our colleagues in the planning department that they have been issued or submitted, I'm happy to close the order. I'm not really concerned with items 1 through 7 as much anymore. But I'm concerned with number 8 on the order, essentially.
Sure. Great. Okay, so I would, again, as a suggestion to the committee, why don't we extend this order? We heard from Mr. Francois that they're happy one way or the other, as long as they don't feel they're under the gun. The, I mean, in a debilitating way. So we would extend it, say, to February. It's halfway between January and March. And we do know, Mr. Hazel, and I think everybody knows that indeed getting your heritage ducks in a row can be an issue. So that would allow for 1, 2, 3, 4 months almost. So, and I think if the owner or staff wanted to move faster than that, they'll soon let us know. So does February sound like a good date to the committee? Yeah, generally, yeah. So we need someone to make a motion to extend the order to the meeting in February. The clerk will fill in the date.
February 22nd, I believe, due to Family Day being on the 15th.
22nd, okay. When this will come back to the committee. Okay.
Yep.
Do I have, sorry? Mr. Clerk?
Sorry, that's correct, February 22nd.
Okay, February 22nd. So do I have a mover? Mr. Storms, seconder Mr. McLaren. Ms. Willis, you're not doing your usual job here. Usually put right there. So any comments? No, it's on the table. Okay, seeing none, all those in favor? Passes.
I'm in favor. It's Bob.
Okay. Oh, good. So, thank you.
I'm on my phone. My iPad conked out. Something happened there.
Oh, okay. Yeah, we missed you there. Thank you.
I'm back on.
Appreciate it. Okay, so that's the last piece of business. I'm going to go on unless the clerk says something. And item number 8 is the motions. We don't have any. 9, notices of motion. I presume we don't have any. Other business, none. Correspondence, none. The date, item 12, and time of the next meeting is Monday, November 16th at 12 p.m. Ms. Willis? Oh, yes, she wants, yes?
Just thinking,
I can't hear you.
oh, come on. Okay. Just thinking about nominations for the panel again. Our terms are at an end, are they not? Shortly?
Yeah. Yeah, I
That's
believe
correct.
that.
The website which includes the application process, should be live today at the very latest tomorrow. So I would encourage all committee members to reapply if they wish to continue to serve on the committee. And I'll be sending an email out once the website's live, just to remind people and provide the link.
Okay, and I would encourage everybody to apply too, because it takes a year or two just to get acquainted with each other and get things moving. And so I hope everyone applies again. And if you have any questions about that, you can talk to James Thompson, the clerk. So do we have a motion to adjourn? Ms. Willis, what do you know? Second by Councilor McLaren. All those in favor, say hi. Mr. Kirk? Are you there?
Yes, go ahead.
No, not the clerk. The member we have on the phone.
Yes, I agree also.
Okay, thank you. And thank you, everybody. And we'll see you possibly in November. We'll see. Okay. Thanks very much. Bye now.
Bye.